the initiative that was passed and failed to exercise it. So I would have resisted that suggestion.
Senator Shockley's next.
Ms. Bradley. Ms. Bradley, please. Brady, what did I say?
Brady.
Did I say Brady or Bradley? Brady, I'm sorry. Mr. Chairman, Mr. Brady, you and I have discussed the another way to handle this. In other words, the person using the marijuana for a legitimate purpose that would be in statute as a legitimate purpose, and the person providing that would both have an affirmative defense under the law if they were charged that either they were entitled to use it because they had one of these conditions and the person that was growing it was providing it. And there would be no need for certification, no need for any proof until they were busted, so to speak. Do I understand the outline of what you were talking about?
Yeah, that's pretty close. It's to completely repeal the medical marijuana law and no longer acknowledge the medical or the therapeutic part of it, which keeps us from regulating medicine, and make amend the statutes for criminalizing marijuana. And so it would be for a very limited number of conditions and a small amount of marijuana, and to make it an affirmative defense if they have a specialist, an oncologist or someone like that, that proves that they have like 4th stage cancer, AIDS, or hospice.
And you would, Mr. Chairman, and you would restrict even more so than this current bill the ailments that they could legitimately use the marijuana for, which I kind of like, but.
I would, and the reason is because of what I stated earlier. There is stuff coming down the pipe. I mean, we're going to have FDA medicine to handle a lot of this as early as 2012.
Mr. Chairman, it seemed to concern you. One of the things that concerned me is if you included pain. It's just so amorphous.
I don't think you can include pain. If there is a way to do it, no one's found it.
Thank you very much, ma'am. Can I talk to Mr. Murphy?
Senator Shockley.
Thank you, ma'am. Ms. Brady.
Mr. Chairman, Senator Shockley.
Mr. Chairman, Mr. Murphy, you heard my conversation with Ms. Brady. Did you understand the dialogue?
I understood the dialogue, yes, Senator.
If we had a model like that, how would it play out for the county attorneys, the people that had to charge or not charge the event?
Senator Shockley, I think it's a proof problem that occurs at trial. As the defense attorneys present on the committee know, affirmative defense doesn't come up until the omnibus hearing, which can occur 6 to 8 weeks after charges are filed, and is not proven by the defense until at trial and is subject to an instruction. It is a problematic situation for someone who may have a complete defense to the offense, who sits in jail for the 6 to 8 months waiting for a trial to have the opportunity to prove his affirmative defense. The county attorneys have consistently through the interim advocated getting rid of the affirmative defense and replacing it with a indication that they have the defense in place at the time the officer first talks to them, so that it doesn't occur 6, 8, 10 months later where the person is suffering the prosecution. And the way this is currently set up in Senator Essman's bill, the defense is established at the time the officer would first talk to the person. because they'd applied. They'd gone through the process and established the affirmative defense only well in advance of ever talking to any law enforcement officer.
Thank you very much.
Thank
Can
you.
I ask one more person, Mr. Chairman?
Follow-up question?
Mr. Quinlan? McQuillen, I'm sorry. Mr. Chairman, sir, I was a little confused by what you said. You said if the current bill, the bill before the committee right now passed or something close to it, that you'd have a hard time advising your clients what was and was not lawful. Did you say something like that?
Mr. Chairman, Senator Shockley, I did.
Mr. Chairman, sir, Quinlan, how about the fact that it's already a Schedule I drug? That's a crime by itself.
Mr. Chairman, Senator Shockley, absolutely. I think that that's basically a given. The voters passed an initiative that was in violation of federal law. So the question is are we going to go with the will of our voters or not?
Well, Mr. Chairman, I was going to ask you that next, but this bill before us can't make the situation any worse because it's already a Schedule I drug. It can make it better. It cannot make it worse, right?
Mr. Chairman, the way that it can make it worse is that it makes it incredibly vague under Montana state law to be able to advise. I'm not trying to advise clients regarding the federal law. We know that. It's cut and dry. But in order to advise them in order to fall under the state law so that they're in compliance with the state law, so that the FDA or the DEA doesn't step in to enforce because the DEA's memo is saying we're going to enforce our policies if the caregivers, the users, are violating state law. So I want to be able to advise my clients to follow state law, and I don't believe I can do so clearly under this legislation.
Mr. Chairman, sir, I'm not sure I follow your logic, but one other question. You and other persons have said we can't overturn the initiative. Well, there's nothing in the law, nothing in the Constitution that makes an initiative any different than any other statute, is there?
Mr. Chairman, I never said you couldn't.
You said you shouldn't, right?
I said you shouldn't. I think that the voters spoke. I think that the pollsters have found that the majority of Montana supports regulation and not repeal. And I think I made it very clear that I believe that as written, without the amendments, this ultimately is repeal, but in a different guise.
Mr. Chairman, but Mr. McQuillen,
Follow-up.
you would agree that we were elected to make laws, to repeal laws, and to change the law. And if we do that with an initiative, at least from a purely legal standpoint, there's nothing wrong with that. This law has been around 6 years.
Mr. Chairman, Senator Shockley, you've had 3 sessions to amend this law and to change it, to regulate it to work. And I think that the outrage by the citizenry, which have supported repeal or regulation, is overdue, and I think it probably should have been regulated years ago.
Thank you very much.